In the case of Jennifer versus AU Hospital, I, the juror, Jermia McCoy, is in favor of the plaintiff, Jennifer. After being served a subpoena that was not court-ordered, AU Hospital claims they made every effort to contact the patient for authorization to release the patient's personal health information, which is required by law. Section 45 CFR 164512 states that a HIPAA-covered provider or plan may disclose information to a party issuing a subpoena only if the notification requirement of the privacy rule are met. Before responding to the subpoena, the provider or plan should receive evidence that there were reasonable efforts to notify the person who is the subject of the information about the request, so the person has a chance to object to the disclosure or seek a qualified order for the information from the court. AU Hospital claims that these efforts were met via letters, emails, and phone calls, but contact was unsuccessful. I emphasize claim because the defendant has shown no evidence, such as returned mail or email sent. I also feel the defendant should have sent a certified letter. Once the defendant exhausted all of their efforts, they felt it was in their best interest to release the patient's information, but withheld patient identifiers. The plaintiff, Jennifer, states that her identifiers were in fact released because she was contacted by her financial institution regarding fraudulent activity. Jennifer states that her gender, place of employment, address, bank information, and other personal information was released. As a healthcare provider, it is AU Hospital's responsibility to protect the patient's medical records and personal information. Due to lack of evidence that AU Hospital made reasonable efforts to contact the plaintiff, I find them in violation of the patient's HIPAA rights.